Welcome to another Texas Association of Realtors video. I'm Ward Lowe. Remember, you can find videos on legal topics like these or marketing, technology, many other videos on the Texas Association of Realtors YouTube channel. That's at youtube.com/Texas Realtors. Today, I'm joined by Abby Lee, who's Associate Counsel at the Texas Association of Realtors, and we're going to talk about property management and security devices. Specifically, there is an article in the September-October Texas Realtor magazine that goes way in depth on what property managers and landlords need to know about security devices with various scenarios. There's a flow chart. It's all very complicated, but we try to make it clear. But today, I'm just going to ask you kind of two quick scenarios about what our Texas Realtor members might want to know. First, in the case of there's an owner who's lived in their home and he moves out, but either whether he wants to or he has to, he ends up leasing his property. What does he need to know, or do these Texas Property Code things apply to him?
So the answer is yes. This would apply in this situation to an owner in this situation. And the reason why is because the statute actually requires a security device operated by a key, card, or combination shall be rekeyed by the landlord at the landlord's expense not later than the 7th day after the tenant turnover date. So you then go back to the definition of what tenant turnover date, and that is actually defined as the date the tenant moves into a dwelling under a lease after all previous occupants have moved out. You'll notice it doesn't say previous tenants. So because he was a previous occupant, this owner, this would apply to him.
Okay. So, and again, we're talking about situations where security devices, locks, and window latches need to be either fixed or changed when occupants, not tenants, move in. So in this case, just because you're an owner and you rent your house, doesn't matter, you're still an occupant, and this Texas Property Code statutes would apply.
Correct.
The other situation, which our Texas Realtor members might be familiar with, is when an owner sells his house but then leases it back from the buyer. Do these Texas Property Code rules apply, or are there some exceptions?
And the answer is no. In this specific instance, the answer is no to the temporary residential tenancy.
Okay.
So in a situation where there's a sales contract, either the buyer leases from the seller prior to closing, or the seller has to lease from the buyer post-closing. There's actually a specific statutory carve-out so that the security device statute does not apply in that situation.
Okay, and is there a time limit on, I forget, on the temporary lease?
It's 90 days.
90 days.
Yes.
So if they were to stay longer than 90 days, then they might be subject to this.
Yes, then these rules may apply.
Okay, and again, the article in the Texas Realtor magazine, September-October, goes into great depth and explains how just because you're the realtor and you're not technically a property manager, if you have a client and they're subject to these, you may have some liability in certain areas.
Well, right, and also keep in mind that landlord is defined differently than it is in this particular statute than it is throughout the rest of Chapter 92 of the Property Code. So landlord actually is defined as a property manager in this situation. So when it says the landlord may face liability with security device, these statutes, it could also include the property manager as well.
Okay, that's some great information, and it's something to be aware of if you have a client in one of these situations. Thanks, Abby.
Thanks.